I'm Ann Catino. I'm an attorney at Halloran and Sage, and I'm here with Casey O'Connell, who is my partner at Halloran and Sage, who practices in the area of business and transactional law. Basically, Casey puts deals together, and whether you're the buyer or the seller, he figures out what's in your best interest so you maximize the benefits that you want out of the transaction. Casey and I are here to talk today about when you have a site in the Connecticut Transfer Act, how a deal is structured and how it's put together. Casey, how is it done?
Well, it can be done many ways depending on the circumstances, which is where us lawyers come in. So when you're dealing with a transaction that could potentially involve the Transfer Act, one of the first items that would be negotiated is a letter of intent. And the letter of intent usually sets out the kind of top line, deal terms such as purchase price and the general structure. However, the structure then needs to get refined as you go through the due diligence process, which typically follows the signing of a letter of intent. And the due diligence process involves a very long list of requests, usually from the buyer to the seller, which says, here are all the items that I need to review as we kind of refine and further structure this transaction that we've tentatively agreed on. One of the items on the due diligence list is almost always, and if not, it should be, an environmental review and a disclosure from the seller to the buyer of any environmental site assessments that have been conducted with respect to the property and any other knowledge that the seller has as to the environmental condition of the property. Depending on where that turns out and how much information there is, the buyer may need to do some additional investigation through a phase one environmental site assessment. And through a combination of the seller's disclosures and the buyer's own actions, it can be determined whether or not a site is part of the Transfer Act. And if a site is part of the Transfer Act and a transaction is subject to the Transfer Act, then that opens up a whole new set of structures as to who's going to comply with the Transfer Act, who's going to be the certifying party under the Transfer Act, and just as important, who's going to fund the necessary work to comply with the Transfer Act. So there's a lot of different, pieces of the transaction that go into determining whether you're in the Transfer Act. And then once that's determined, it kind of opens up a potential revision of the structure to figure out how to best comply with the Transfer Act in a way that's acceptable to both parties.
Well, the Transfer Act requires investigation and remediation of the property according to DEP standards. Now, one of the parties to the transaction has to be responsible. Does it always have to be the seller or can it be the buyer?
It could be the seller or the buyer. I mean, per statute, the seller is typically responsible. And if there's no compliance, then the buyer could go back and look to the seller post closing of the transaction for remedies. However, like with pretty much any part of a business transaction, there's negotiations that can occur, and sometimes the parties feel that a splitting of the responsibilities is more appropriate. Sometimes some party pays for one portion, some party pays for another portion, but it really depends. Like, that's one of the things that in our profession, when people ask for a black and white answer, the answer is not almost always, but sometimes it depends. So that, I think, is the case here.
Well, with the Transfer Act, somebody has to sign on the dotted line and be responsible to DEP. So if somebody has to be responsible and it's the seller, for example, because the buyer doesn't want to be bothered with it or bear that responsibility, how can the buyer be assured that the seller will perform?
Well, it's a matter of making sure that funds are reserved for the performance of the required work. And if the seller does not perform the required actions, then the funds need to be available for the buyer to obtain control of those funds and use the funds to perform the work itself. And the mechanism for that to happen is almost always an escrow. And typically there's a escrow of funds in a transaction for general violations of representations or warranties and post-closing liabilities that the buyer can use to remedy any deficiencies in the transaction from what the seller had represented it should be. However, in environmental matters, typically there's a separate environmental escrow that really just deals with the Transfer Act, because it's such a discrete set of issues that need to be dealt with, and it's typically a known liability, as opposed to a typical escrow would be for more of a contingent liability or potential liability, whereas since the Transfer Act would almost always create a liability that can be quantified to some extent by the value of the work that needs to be performed to comply, that would lend itself to creating an escrow that is a separate escrow that has money that's available strictly for the Transfer Act compliance.
And to come up with the appropriate figures, we typically work with environmental consultants who do some sort of investigation and help us with cost projections so that we have a better understanding as to the amount of the escrow. On the flip side, sometimes the buyer will be the certifying party. In that case, have you seen price reductions based upon the cost and the risk that the buyer may be undertaking if they're the certifying party?
Right. Yeah. That would be certainly one way to structure it, where if it's the seller's responsibility, the money that the buyer would be paying to the seller, portion of that would be held back. But if it's the buyer's responsibility, they would just reduce the purchase price, or come up with some sort of additional structures within the purchase price to maybe have part of it be contingent on how much work the buyer has to do post closing. So yes, there's many ways to structure it, and like I said off the top, the letter of intent kind of indicates the initial thoughts of how the transaction is going to proceed. However, once you get into due diligence, there could be other items, as the things that we're talking about, that can come up that could cause some changes to that structure, like in the form of an escrow, or in a purchase price reduction, or in some sort of alternative structure to make some of the purchase price conditional on how the environmental matters play out post closing.
As you can see, dealing with the Transfer Act in the context of a transaction can be very complicated. If you believe you are going to be buying or selling any piece of commercial real estate, please call one of our Halloran Sage attorneys, and we'll be glad to help you through this and evaluate whether or not the site is a Transfer Act and what kind of transactional documents that you need. Thank you.
Thank you.